Thank you so much for joining us for our panel discussion. I know it's late in the day, but we are very fortunate to have such an experienced and esteemed panel. I'm going to give them an opportunity to individually introduce themselves and explain their role in the elder well justice sphere.
Okay. Hello, everyone. My name is Judith del Cuadro-Zimmerman. I'm the managing attorney and founder of del Cuadro-Zimmerman PLLC. We are a law firm that focuses on a wide variety of fiduciary law, and one of the services we provide is serving as guardian and conservator for individuals in the district. We also serve as counsel to folks who are going through intervention proceedings and represent family members during those proceedings.
Good afternoon, everyone. My name is Keri Flora. I'm an attorney at Quality Trust for Individuals with Disabilities. We're a nonprofit monitoring and advocacy organization, and our legal team focuses on promoting alternatives to guardianship, like supported decision-making, powers of attorney, and we also help people try to get out of guardianships that might be undue or overbroad.
Hello, my name is Cherlitheia Irving. I may come across your desk as Cheryl Irving. I contract with the DC Probate Division, the Guardianship Court, in the role of examiner and visitor. I'm a licensed independent clinical social worker for the District of Columbia. I have a small private agency, CSI Consulting, where I assess, identify, and connect residents to services in the city.
Good afternoon. My name is Jennifer Mika. I am counsel at Crowell and Mooring in their healthcare practice group. Before joining Crowell, I spent 13 years in various positions in DC government and federal government, including working on guardianship matters with Neha at the Department on Disability Services. I served as the district's first prosecutor solely focused on financial exploitation of elders and vulnerable adults, and I've also served as the pretrial mental health coordinator at the U.S. Attorney's Office.
Good afternoon, everyone. Thanks for being here today. My name is Neha Patel. I'm the Deputy General Counsel at the Department on Disability Services. Along with my colleague, Judd Kempson, who's here today, we help advise the agency on all issues regarding consent and decision-making, but we also petition in the probate division when people need guardianships or when the agency's information about a person is necessary for the court to determine whether someone needs a guardianship or not.
Thank you so much for introducing yourself. We have a great panel of experts. What we are going to do today is a facilitated discussion. That means that our panelists have been privy to the questions prior to this session. And we are going to use a case that has been very publicized in the news. We're going to talk about the Wendy Williams guardianship case. I'm going to start the PowerPoint presentation. Just a disclaimer that the contents, materials, views of those of the moderators, facilitators, panelists, and speakers do not necessarily represent the official views of nor an endorsement by ACL, HHS, or the U.S. government. So we're going to just go quickly through these slides so that we can ask questions that give some background information. So Wendy Williams is a media personality. She's a former radio host, daytime TV show host of the Wendy Williams Show. She stepped away from her show in 2021 amid health issues. Her health issues and diagnoses include, over the years, she's had disclosed Graves' disease, lymphedema, among others. And in 2023, she was diagnosed with a primary progressive aphasia, frontotemporal dementia. Some of the financial and legal issues. In early 2022, her bank, which was Wells Fargo, froze her accounts, citing concerns about her mental state, possible undue influence, or financial exploitation. Wells Fargo petitioned for a court-appointed temporary financial guardian. A court-appointed attorney, Sabrina Morrissey, was appointed as her guardian in May 2022, giving her legal authority over Wendy Williams' financial, medical, and personal decisions. Some of the contested issues and disputes Ms. Williams has publicly disagreed with the diagnosis. She claims she is not cognitively impaired. She has described her situation as very restrictive, comparing the guardianship arrangement to being in prison. There are concerns and legal actions from family members, including her son and ex-husband, over financial mismanagement or abuse under the guardianship. Some of the recent developments is that a recent medical examination that was completed reaffirmed her diagnosis of frontotemporal dementia and aphasia. That evaluation included neuropsychological tests and brain imaging. Her guardian has requested an extension of the guardianship until November 5th, 2025. So some of the arguments that are in favor of this guardianship is that medical evidence supports incapacity. Again, her doctors diagnosed her with frontotemporal dementia and primary progressive aphasia, both progressive conditions that impair judgment, communication, and financial decision-making. Financial protection is needed. Wells Fargo again froze her accounts in 2022 after suspecting she was being financially exploited or unduly influenced. The court agreed, appointing a guardian to prevent further potential exploitation. Independent medical exams also uphold the diagnosis. Again, she's had recent testing that reaffirmed her diagnoses. And that guardianship ensures stability. Having a court-appointed guardian in place protects her assets, her health care, and personal welfare, while she may lack capacity to do so. Now, some of the arguments against the guardianship is she denies impairment. She's publicly said that she does not have dementia or cognitive decline, and that she is mentally capable of managing her affairs. She's compared the guardianship to being in prison. She says it's restrictive and isolating, claiming it severely limits her freedom and autonomy. She, again, the financial mismanagement under guardianship, her family members have asserted that the guardian mishandled or improperly controlled her finances. There's also assertion of lack of transparency. Guardianship proceedings are sealed. Her family has argued they've been excluded from information and decisions about her care and her money. And this is just a general timeline of events. From 2018 to 2020, Ms. Williams publicly discusses her health struggles, including Graves' disease and lymphedema. Her health concerns occasionally disrupted her daytime show. In 2021, she stepped away from her show due to health issues, and speculation started to grow about her ability to return. In January 2022, Wells Fargo froze her accounts, claiming she was a victim of undue influence, financial exploitation, and improper conduct. The bank requested a temporary financial guardian. In May of 2022, a New York court appoints attorney Sabrina Morrissey as Wendy's permanent guardian for her finances, health, and personal decisions. Wendy disputes the decision, saying she is mentally capable. In 2023, her team announces she has been diagnosed with frontotemporal dementia and primary progressive aphasia. Supporters, including family, raised concerns that the guardianship is overly restrictive and mishandling her estate. In early 2024, she gives interviews claiming she is not cognitively impaired and feels trapped in the guardianship. Family members publicly criticize the guardian, alleging financial mismanagement. In late 2024, a comprehensive medical evaluation confirmed her actual diagnoses, and the court extends that guardianship. And in 2025, so far, the court filings show the guardian requested an extension of control until November 5th, 2025. And as we see, the debate continues in reference to the guardianship. All right, so we're going to ask our first question. In your professional assessment, what specific factors or events likely triggered the initial petition for guardianship or conservatorship in her situation?
I'll go ahead and answer that one. It appears that there was concern about financial exploitation. I guess I'll elaborate away from Ms. Williams' case a little bit. This is a common reason that conservatorship and guardianship cases come into the DC system. And in my experience, oftentimes it's too late. The financial institutions don't act quickly enough. By the time this case moves through the court system and appropriate protections are put in place, oftentimes tens of thousands, if not hundreds of thousands, have already been drained from the individual's bank account. And the really troubling issue that arises when that happens is usually that person is in a very vulnerable point in their life. It changes the ability for you to plan for their care, right? If they had all these resources previously and they now have nothing, the care plan becomes extremely difficult. The options that the now guardian and conservator have are often extremely restricted at that point. So yeah, that's been my experience when things come in through financial institutions.
I would say this is, I think Ms. Williams was lucky in a sense that I think because of probably the amount of assets that she had and probably just her status that Wells Fargo took this kind of action. I think it's actually quite rare for financial institutions to initiate these types of proceedings. And so to your point, oftentimes a guardian is coming in much later after most of the money has been drained and other people have started identifying that is an issue.
Can anybody speak to the medical conditions, or, it was very public. It was on the screen seeing her pass out and things like that. Can anybody speak to how that would have contributed to that decision?
How you doing? I just wanted to say, okay. So, a colleague of mine said that I be social working these cases, and I really do. Ms. Williams' medical conditions and even the circumstances started many years before Wells Fargo became involved. If you look at it from a psychosocial, macro level, there was severe substance use. There's alcoholism. There is medical conditions. I think all that built up to where she is now with the dementia. And I think because she has so many assets and you can even tell on some of these documentaries, and she was making money for so many people that she may have been petitioned or something, intervention in place a long time ago, but everyone turned a blind eye. Mm-hmm. And Wells Fargo took the initiative to bring it front and center. And so that's how medically, everyone knew that she was going through a lot of things. I mean, she publicly speaks about it, but I don't think it was one isolated condition that led to this. Mm-hmm. It was a plethora and a coordination of everything that led to Ms. Williams' condition.
Right.
So I applaud Wells Fargo.
Right. Given the high-profile case of that, if you had to do a capacity assessment, how can you ensure it's not biased or, because she's in the public eye? What are some of the things that, we should pay attention to so that we make sure it's fair, thorough, but unbiased?
So,
No, you go ahead.
So absolutely, you have to, like I said, you still have to look at it from a holistic point of view. You have to dig and get information and bring everything together. She often spoke about, allowing her son to just have his way with her finances because she felt really guilty about being away from him for so long. And he was allowed to have free range. However, when a person's condition changed, then so should those conditions that were in place before the change. Mm-hmm. And so you have to look at that. You have to look at safety. It's not about finances, was the ability to keep herself safe, the ability to, meet those contractual obligations that were put into place before her significant decline. Mm-hmm. And so as an examiner, it's not about using formal assessment tools. or, you send someone, the guest that was up here, who doesn't physically look capable, or just, one incident, you have to come from a holistic perspective and put it all together.
Mm-hmm. And she gets counsel, who is another protection for the individual. We get to examine those reports, and if she wanted to contest the guardianship, we would cross-examine Ms. Irving's expertise and her findings, and that's a critical part of the legal process for the individual.
Anybody?
Yeah, I was just going to add, the way we approach each of our clients is with a presumption of capacity. That being that each adult we have the assumption that they have the capability of making their own decisions until evidence proves otherwise. Obviously here there was some evidence, but a part of that is understanding, I think the question that maybe, I don't know if it was asked, but is what is she able to still do? At that point, were no alternatives possible? And I know we're going to talk about that more and what alternatives could look like in this situation, but I think that should have been part of the evaluation.
Very good. We are going to talk about that now. So, guardianship is often seen as the last resort. Given what you know about this case, can each of you discuss what alternatives might have been considered?
Shall I continue? Okay. So obviously we've talked a lot about supported decision making and how it is the least restrictive alternative to guardianship. And, in terms of capacity, someone like Wendy, for example, might not have the capacity anymore to make certain financial decisions, but it could be that she could have the capacity to make those decisions with support. And so I think that's how we have to reframe the thinking of capacity, and that supported decision-making is a legal option in DC and New York City, or in New York. And I think that's where her case was, right? Okay. And so those are meaningful alternatives that need to be explored before going straight to guardianship.
And I'd agree with Keri completely. I think the one question I would have that I think we should always consider is, even if she can make decisions with support, are there people to provide that support, right? There's some question, at least from what we're seeing, about the family and their honesty and ability to take care of her, or at least not exploit her. So there's a question of who would provide that support. And the idea of supported decision-making is to avoid having to go to court to get someone in place. So is there some other natural support that could step in that is trustworthy and honest and someone she would trust? Mm-hmm. And that's kind of a questionable thing, at least given the facts of this situation.
I would say the same barriers should be discussed for other legal alternatives like power of attorney. That's sort of the natural next thing to explore here. But of course, in order to select a power of attorney, the person has to have at least relatively good judgment. Mm-hmm. And again, it appears that the people closest to Ms. Williams in this case may have been the ones to be exploiting her. So if they can't serve, then who would in this case?
Yeah, and Ms. Williams has a very bold personality and supportive decision-making. While it's a good least restrictive option, I don't think it would have been in her best interest, taking into account her celebrity status, her access to finances. She tell people what to do. And just like I said earlier, is that everyone knew what was going on and should have stepped in and didn't. And so I think a neutral party was the best alternative for her at that point, yeah.
Say that a least restrictive environment was available. What types of resources can you all share that would help implement it, making sure that the plan was followed?
I think you heard some of the words just in some of the things we just talked about, but obviously supported decision-making is the primary one we would try to use if she had a support that was trustworthy. Similarly, with the durable powers of attorney or advanced directives, all that estate planning that in almost every session I think someone has talked about doing for yourself, for your loved ones, for the people you're supporting, Those are the main avenues we would go to if it was possible for her. And I will say one of the things that, I know there's another question about this later, but one of the holes, I think, in all the systems around the country, and especially in the district, is this idea that for people who don't have natural supports, we don't have a lot of choices outside of going to guardianship if the person lacks capacity. There aren't any natural structures. I know, I had this conversation once with folks at Whitman Walker, because they wanted to figure out, is there a way, the way that we have a guardianship panel, that we could have a panel of people who could be trained, be trustworthy, that could serve in these lesser restrictive roles for people who don't have family, who don't have natural supports. So for instance, in the disability arena, we work with a lot of people who've lost their natural supports, or their natural support is not a trustworthy person. That's not to say that's the case for everyone, but it is a common theme, this lack of natural community support. So that was something that, in an ideal world, we would have that system as well, something available to have a community resource for people to serve in those roles as a supporter, as a durable power of attorney, as something else, and in order to give people these lesser restrictive options in a meaningful way. And that's something that, hopefully someday we'll have in the district, but we don't right now.
Right, because it's really unfortunate when somebody could have the capacity to use something like supported decision making, but they're put under guardianship because they don't have that option.
But we're also seeing, at least in guardianship court, there are now, we're really promoting people doing estate planning, these other alternatives. And yes, guardianship is the last resort. But unfortunately, people's estate plans are not foolproof. We have many, many cases that come in where people have a power of attorney in place and it's failed for some reason. Either the person who's been nominated as the POA can no longer serve, or they're being accused of mismanagement or malfeasance. All these issues are reasons that guardianships come about.
Yeah, so for this one, just like, when individuals are facing legal troubles, they put together a high-powered team of attorneys, and this could have been done the same. You could have put together a really high-powered clinical coordination team of doctors, a power of attorney, legal representatives, and you could have case managed this under the table. And it still could have had court oversight without going to guardianship as restrictive as it is. And so this is along the line what Ms. Patel is saying. A team of individuals. It can be private hire. There are some private case consultation teams out here, or us as a district looking at how we form those really highly effective teams within our own agencies here in DC. We have a lot of them. I think it can be done.
Yeah. That's a very good point. Very good point. So in the Wendy Williams case, there were reports of financial irregularities and misuse. What are the key red flags that we should look out for? And what immediate actions can be taken if there are red flags?
Pretty sure this question was just for me. Anyone who came to the session that I did earlier today will know some of these things that I'm about to list out. So, sudden changes in financial behavior. So I think that's obviously what the red flag was for Wells Fargo here. Just changes in hygiene, people showing up that are suddenly new in your life and seem to be kind of controlling what the person is doing, limiting access for other people. Those same people showing up on bank statements, or suddenly mail coming for those people to the house. Just sudden changes, things that just seem out of the ordinary for folks are huge red flags. It also, you might also see, and it could be either way, right? So it could be that suddenly the person doesn't seem to have any money for food, or seems to be just behind on bills, and it's kind of unclear why, because they've always been really good about keeping up with their bills. Or it could be the opposite, where suddenly they seem to be having a very lavish lifestyle, or they want to be spending more money, and it's because they want to spend it with somebody who's new in their life. and at the expense of a number of other things. So those are some of the key red flags. And then in terms of ways to immediately to kind of stop the hemorrhaging, stop the outflow of money, obviously contacting financial institutions, having a trusted person listed with your financial institutions that is allowed to get information about your accounts. They can't make any decisions about it, but just they can they can get information from the bank and then be able to assist you. And then, kind of stopping those, figuring out, the first thing is figuring it out, which oftentimes is probably the hardest thing to do. And just getting as much information as possible, and then just trying to prevent that person from continuing to get access to those funds.
Thank you for that. So this is a good question for all of us in here. All of us are various professionals. Can any of you provide an example of an interdisciplinary team that collaboratively worked to help successfully protect a vulnerable adult?
Recently, for instance, we did a case with Adult Protective Services together where APS was examining the situation for a mother and a son. We had been, as the Department on Disability Services, trying to provide services to the son. And he needed total care, completely unable to express the things that were important to him or what he wanted, and needed almost 2 aides at a time to assist. The mother had been exhibiting signs of, diminished capacity issues with our service coordinator would go to visit, and she would, answer the door, talk to her, walk out of the room, walk back in and say, "Oh, when did you get here?" That kind of thing. Piles of bills, both of them very thin, not finding food in the cabinets, even though aides would report that they paid out of their own pocket to bring food into the house every day. So someone in the building was coming and taking the food, and she didn't remember any of that. So we were working alongside APS to investigate the whole situation. We decided to file at the same time, ask for it to be heard by the same judge because the facts were very much similar, at least what was affecting them both. And again, in this situation, the mother was online with us, very upset that we were having this hearing. Clearly loved her son, no question about that. But when people would say things like, "Do you understand that you're about to be evicted?" she would say, "I'm elderly, they can't do that." "Do you understand that you haven't paid your rent in 2 years?" "Yes, but they can't do anything to me, this is my apartment," right? And it kind of went in that circle, and sure enough, in the end, the court did decide to appoint guardians for both of them, separate ones. The guardian for the son went to visit shortly after, and the mother did not remember the hearing at all. Even though she laid into Judge Ross, and Judge Ross was, I've never heard anyone talk to him like that before, but he was extremely patient, extremely kind, and understood what was happening, but it was one of those things where we were able to work together with their social worker and our service coordinator went into the home together prior to the hearing a number of times, tried to check on the food, bring food to see what was going on. And then the people appointed in the case, because we had about a month from the time that the petitions were filed till the hearing was going to happen, they were also reporting back to us when they would visit to say, "Actually, I went and there's no food again," right? And so then we could tell APS and our service coordinator to go out and they would do it again. So it was a real team effort on that one, and I really appreciated that. It worked very well for both of them. I don't know what's going to happen going forward when we have to figure out where they're going to live and how this is going to work. The mother is definitely not going to be happy when changes are made of any kind. But part of the other point that we had to make to the court is that she was preventing our staff from going in and providing services that her son needed because she would forget who they were. So when they would show up, she would call the police on them or kick them out or scream at them or let them in nicely, and then 10 minutes later, "Why are you in my apartment?" Right? So we had to coordinate all those stories because even though we knew those stories, and in a way it kind of goes along with Ms. Williams, is, you might see things, but we have to prove them in a courtroom in order to make it viable evidence, right? So it's not just, I think that she has dementia. She seems like she might, We needed an examiner. We needed someone to try to go and do the assessment for us so that the court had real clinical evidence, not just what we saw on TV or not just what we heard in the, in the paper or on the internet. So I think it's important to have all those facts, and then for lawyers to have real testimony, real information that can help the court that's factual and not just biased or based on social media or based on what's out there in the media.
Mm-hmm.
So I like to answer that there are no formal MDT for adults. And so I'm just going to bring this. I never really understood what it said, once a man, twice a child, because, you start here as a child, you go up, and you're back there. And so our elderly population are just as vulnerable as our children. Now, there is a formal multidisciplinary team for children. In cases of sex abuse and severe physical abuse, where it's Child and Family Services, DC police officers, the Child Advocacy Center, Children's Hospital, the OIG office, and you meet regularly, twice a month, and you're sitting there, and everyone's bringing every component to the table. And we're leaving out there either with an arrest warrant or action plan, and it's not. And so I found with doing this, like Ms. Patel said, you have to create an informal MDT. I'm getting on the phone, I'll call counsel and say, hey, I know what your role is, but just listen at what I found. You still want to take that position? Okay. And I'm creating an informal, and I believe that there needs to be one, or we need to put that on the table. That's a parking lot item we can take away.
Yeah, I think part of that also is engaging providers, so facilities and other entities that are providing supports for an individual, to make sure that everybody is involved and that they are interested and are informed about decision making and supported decision making, because I think they're providing vital care, but they're also in a position where it's in their interests to address these issues early on. They have their own potential liability associated with exploitation, and so I think engaging with them, one of the other panels, the speakers talked about the importance of us going forward from this conference and educating other people about these issues. And I think that's one area where we could get buy-in and really engage with providers to be part of this discussion, because I think they need to be.
Okay, so in your experience, what is the single greatest challenge you face in your daily work within the guardianship system, and what is one reform you would like to see implemented in the DC area? I see smiles over there.
Are the judges here? No. Personally, just as a selfish problem that I have a lot, is that our agency doesn't always get notice of hearings for guardianships that are filed by families. And there has been, in the last few years, I do an annual report for our agency every year to the council, and this year we filed 2 brand new guardianships. When I first started at EDS, we were filing 200, right, in a year. So majority of the cases that we've been attending this year, and there were something like 60 of them, were filed by families, either prior to coming into DDS intake or sometime in the year that they were in the first year of their services with us. So we're finding this trend where families are getting advice from somewhere, potentially, HSCSN, DCPS, someone out in the community, a clinician, saying, hey, when your kid turns 18, you have to go get guardianship for them, which just isn't true. And so I keep trying to chase down the source of this advice to try to do some education, because it is creating a whole host of young people who start out with a guardianship at the beginning of their adulthood. And it may be well-meaning. I'm not trying to say that families are doing something horrible. They're not. They're trying to help and protect their loved one. I get that. But there are less restrictive ways to do that. So So when they file these guardianship petitions, there are times where we come to court and say, actually, based on what we know, this young man doesn't need a guardianship. Look, he's about to have all these services and supports. Why don't we try one of the lesser restrictive options first? And the court has been receptive to it. But us not getting notice is the hardest part, because we find out because Ms. Irving calls and says, hey, there's a hearing on Monday. Oh, okay, it's Thursday. We'll get there, we'll get some information together, and we'll show up. And that can be very difficult for Mr. Kimson and I, as it's a lot of running around and making sure we have accurate information to provide to the court. But along with that notice in terms of a reform, one of the other things that has been a consistent conversation with the court, and I think it just depends on who's issuing the orders and how that works, when a new guardian is appointed or a successor guardian is appointed, if it's a member of the attorney panel, if the notice that's going out doesn't have the contact information for that guardian, how is the person or their family supposed to know how to reach that guardian, right? Or even for counsel, GAL, examiner. Frequently, because now we do everything through the e-filing system, it's just the email address that's on there, not a phone number, not an address. Most of the people we support, their families are not using email for that reason. They're not going to be able to just Google it and get the information they need. And a lot of that information can be hard to find, even for practitioners, right? There's a list of the panel that we can ask the court to give us, but it's not as easy to know how to reach out to your guardian or your attorney before a guardianship hearing. And so that's something that, every few years we sort of talk about again and we fix, and then maybe there's a new set of clerks and it goes away. But I think that it's a real due process problem for people. They need to have access to how to reach their advocates. And the court's issuing those orders. So that's one thing I would love to see reformed and be uniformly there, so that we're making sure people have their rights protected.
My one thing is actually more related to addressing financial exploitation in these contexts, and that is that currently under DC law, it's you can't go after the property of an exploiter and try to kind of recoup money by repossessing the cars or garnishing their wages or something in order to get the money back that they have taken from somebody. Currently under DC law, there's no ability to take back that money for financial crimes, which doesn't make a lot of sense to me. So I think that's something that is an easy fix, but there just needs to be political will and interest to do that at the DC Council.
And can you repeat? It was a two-part question, right?
Sure. Just what reform would you like to see? What's the biggest challenge you have, and what reform would you like to see in the guardianship DC realm?
Yeah, so as far as reforms, I would like to see some official teams put in place through the DC agencies, like the MDT, like we have in place for other children. That's the reform. And the biggest frustration is, I have a lot of transferable experience and being in child protection for so long. I bring some of those, but we fought really hard to keep a removal from happening. We used all our resources that we had in the community and called on family and had contingency plans. And I want to transfer that over to the to our elder care. And the biggest frustration is that, I'm new to this and I come with some great ideas, and just getting everyone who's done this for years to just see the bigger picture and be open to change. Change is necessary. When you hear this is how we done it, and what is this least restrictive? Just listen, be open, and that's the biggest frustration. When you come in and you putting things in place, and it's just like guardianship. I'm like, no, there's some different things to be done, and so. Yeah, that's the frustration. But I can tell you where the guardianship things are coming from. Give me a call. Yeah.
Along the same lines as what Neha was mentioning, especially with young people, is we would love to see the courts having people meaningfully explore alternatives before going to guardianship. So like we heard earlier, I think it was in Minnesota, their new petition for guardianship requires them to provide evidence that they have explored alternatives before they even file that petition, which I think would be a really meaningful addition in DC. As well as, again, I think this is more along the lines of younger people, but we know that sometimes guardianships are necessary. We don't live in a perfect world where they aren't sometimes necessary. And even when people are placed under guardianship, we know that if people have the opportunity to practice decision-making, that their capacity to do so can grow and evolve over time. And so even within that guardianship context, if they were practicing supported decision-making informally, even guardian to ward, they might have the opportunity to down the line restore their rights and terminate the guardianship and start using that alternative instead.
I think the biggest change I'd like to see is a lot of what this conference is facilitating, which is a more nuanced conversation around guardianship. Very unfortunately, the publicity that cases like Wendy Williams and Britney Spears have brought to the guardianship system is that people automatically, the general public, families that are involved in this system, automatically think the guardian and conservator is the enemy. And that doesn't help anybody, right? In the most ideal system in which we are using a guardian as the last resort, you know, other alternatives have been explored and eliminated. We're working in cooperation with the people closest to that individual so that we can mend the social fabric to support them. That's really what a good guardian is trying to do. And I see that out there. It's just the publicity that has recently come about because of these high profile cases is mostly negative. And this is a necessary system. It's necessary here, it's necessary throughout the country. We all need to do a better job discussing these things in a more fulsome way.
What great suggestions. I appreciate you all being honest and forthcoming with that. One last question. If you wanted to present a great takeaway to our audience members, something that would improve best practice, what would you want them to leave with today?
Yeah, I want you to be open. Stop pushing your own agenda because it's yours. I want you to look at what's in the best interest of the subject or the ward. But I also want you to think about why has there been guardianships for Brittany and Wendy and not Kanye?
I don't even know how to follow that. I will say, at DDS, our main focus is trying to be as person-centered as possible. So once again, it should be about the person. When does the person want to have their meeting? How do we balance the rights and wants and needs of that person with the things that are necessary to keep them from being exploited, right? And as people age, as people deal with illness, with disability, that line in the sand shifts. And so thinking about when are we crossing that line into having to do something about it versus there are so many simpler things we might be able to do outside the box to help this person continue to be independent, maybe with some supports that grow over time. So just trying to make sure you think about that line, but always keeping the person as the central thing.
I would say document. So not just like both encouraging people to document their preferences, their what they would want in later in life, what they would want if they are no longer able to make decisions, making sure everybody knows where their bank account, what banks that they bank at, and like where their finances are maintained and who their contact is for what. So that document in terms of, when you're advising people and connecting with people, but then also for yourself, do the same thing for yourself, but also, and as a practitioner, make sure that you are documenting and maintaining good practices for yourself and how you are managing things for other people, and to ensure that that there aren't any issues that arise either from what you're doing or from, for yourself and for others. So document.
And I'll just reiterate again, exploring every least restrictive alternative before guardianship.
Moving away from when a case initially comes in and you do need folks with legal expertise. Once a guardianship or conservatorship is established and someone is appointed, you're really looking for someone to exercise good judgment. And that's really, that's a tool that all of us can exercise, and you don't need to be a lawyer to do that, right? To serve this individual the best way that you can. So for me, it's exercising good judgment.
Yeah, and two, guardians can also put services in place. It's not just maintaining them in the guardianship. Okay, we're here, if we bypass least restrictives and we're at guardianship, how can we, assist this person with regaining? Some is access to adequate medical care. Some is access to adequate resources in the community. Just exploring what does it take. You have a person, like your couple, Ms. Patel, who's thin. What providers can best service them where we can have eyes, like our frontline workers, use our frontline workers as least restrictive measures. Mm-hmm. And so it's, guardianship is about, protecting, keeping safe, making good decisions, but also a responsibility to provide them resources that can return them to capacity. So
that's an excellent point. So you all see the wealth of knowledge we have here. So this is your opportunity to ask questions. We have a mic back there. Just raise your hand and we will proceed.
Thank you. I just wanted to comment on the Wendy Williams financial influences that seem to indicate the bank was kind of exposed. Earlier we mentioned about shouldn't the banks have more responsibility when somebody brings an elderly person into the bank and gets them to sign a paper and they walk out with a reverse mortgage on their house or some loan or they taking money out of the bank, and the bank basically knows that this person is being taken advantage of and then basically does nothing but give the money to whoever's with the person to take the money. But in the Wendy Williams case in particular, she had a husband who had, I believe, if I got my facts straight, a child by another woman who then she divorced and then owed spousal support of over, I think, $200,000 or more per month. She had a son who was living in a $2 million Miami apartment paying over $2,000, $3,000 a month rent. And I think the bank saw that her account balance was going down because, realistically speaking, I think she voluntarily decided, in addition to having her health problems, she decided, I'm not going to keep working and paying all this money to my spouse and paying for his new family, for his new baby's mother, whatever. The bottom line is, I think there were financial pressures that led to maybe her health breakdown, maybe the bank finally seeing the balances dwindling, but I think that had a lot to do with the bank filing on her behalf for guardianship. Contributing factors. I'm sorry. Thank you.
Yeah, so the first thing is, and I think I mentioned this in my session earlier, is that banks are all required by federal law to submit what are called suspicious activity reports, and they go to federal law enforcement, and they're sealed. They can't be used in court proceedings because they're just allegations, right? They're the way that all banks have to do this, report suspicious activity, but then it's on law enforcement to do anything about it. Certainly banks have some responsibilities in terms of they have flexibility in their ability to say, no, I'm not going to allow this transaction to go forward. But it's limited, right? And so they are in a tight spot, right? Because on one hand, their duty is to they do have this obligation. They don't have like the mandatory reporting requirements like a social worker or something like that. They have the SAR, and once they submit the SAR, they've kind of fulfilled the federal legal obligation that they have. They do have some exposure though, right? And I've seen cases where, but if they haven't done if they haven't done that alert, if they haven't taken other steps that are consistent with whatever their internal policies are about how they address suspicious activity or fraud or abuse, then they can get pinged for that. But I do think, like that financial institutions are in a tough spot, and that there are certainly obligations that they have. Could they be stronger? Maybe. I think also it's interesting that they actually took the additional step of seeking a temporary conservator. I've honestly never seen that before, and I don't know if that's a unique thing to New York where they have the ability to do that. We certainly see some of that with hospitals here in the district, but I think it's an area for further exploration. I think that there have been some good movement for financial institutions to be more mindful and have better practices to prevent fraud and exploitation. But it's still, they have a lot of different fiduciary obligations at play, and that really complicates how you regulate that area.
And I just want to say, too, that some of the best plans that you can put in place don't always work out the way you think they are. Yeah. You can identify the most responsible family members and well-represented institutions, and, you put it in place, and then, you find out, okay, they, too, are now exploiting. And so it's about doing what's best. It doesn't mean that it's always going to work out, but there's still opportunities to come back and revisit.
This is one of those lines also that's so careful, we have to walk so carefully. Most of this conference has been about how we can give people autonomy, and oftentimes, they're the ones who are taking out extraordinary amounts of money and spending it, I would say, inappropriately, right, or without judgment. And so, this is part of that balancing act. How much autonomy does the person get to make those poor decisions, and how much should we be protecting them?
And I will say that we've, at least in the last few years, had a run of the DC banks being very strict, to the point that panel guardians who have letters of guardianship are still being turned away at the bank to try to get information or help the person that they're trying to support. Our provider staff who might be there to help the person open the account subsequently can't help them get information about their own account. So the DC banks are taking it pretty seriously. I don't know about other places, but we definitely have run into a lot of difficulty with that lately, that they're taking it sort of to the other extreme.
Hi, I'm Julie Rones, and I'm on the Probate Fiduciary panel. And I'd like to thank all of you because it's been very interesting what you had to say, and I've got a lot from it, as I'm sure we all have here. I have a question, though, as to when you're trying to protect your ward. And it seems like I had like a case it was just horrible. All kinds of things were going on with a person with intellectual disabilities. And I tried to get a stay-away order, and I was told that I didn't have the authority. That person would have to go before the court themselves and say that they wanted it. But that person had an intellectual disability, and I felt was really getting exploited. And so my question is, if there's a need to change some of the statutes to allow for more protection by the guardian of the ward, is there a process that can be utilized to tell the court that, I think this is a problem? And the court was very inconsistent in addressing the issue for a temporary stay. The judge said, oh, well, as the guardian, if you think that this is important, we're going to put the stay in place. Coming back for the permanent one, I was no longer the guardian, but the guardian was told you have to have the person. That person has to ask for it. You don't have the authority. So I'm basically asking, when you sense you have these roadblocks in the court system, what's the best way to go about trying to initiate reform so that you can do your job to protect the ward? Thank you.
Hi, Ms. Rones. Good to see you. Appeal. Appeal. We need to be appealing more. Our practice area doesn't like to do it. There's no case law out there for us. We need to appeal. Let's make some case law, make it favorable so that we can do our jobs. Because you're right, every time we get a new crop of judges on the bench, new results come out, right? We don't have any case law. So that's what I would recommend.
I had a question that was sort of triggered, I guess, if you will, by the indication of a large number of parents coming to get guardianships for their children, and then the response saying that people need to be looking for other avenues. I'll start with the fact that I was among those 7 years ago, but my son has severe autism, and that was the only alternative. But what I'd like to know more about is not every 18-year-old is created equal, and we have a whole range of capacities, and many of these children are extremely vulnerable. And when parents come to me in the future and they say, well, what can I do to make sure that my child doesn't move to Oregon with some random person, or any number of potential scenarios, that what are the other ways of doing? I know there's a whole bunch of ways you need to work with your children, but as far as making legal protections to sort of stop the worst case scenarios, if they're possible, how do we do that?
Okay, so that's a large question, but I will try my best. First, I do want to point out, and one of the things you said made me think of this when you said, oh, I don't want my son to move away to Oregon with somebody else, right? Even a guardian can't always prevent that, okay? It's one of the things we learn and we talk to with our teams all the time. If they say, oh, get a guardian, we need to do this. The guardian can't necessarily make the person do what's best for them or prevent them from doing the worst possible thing. They can sometimes. Sometimes it can still happen, right? So it's not a foolproof thing no matter what. I do think that it is worth examining whether or not the young person has the ability to understand a durable power of attorney and give the parent that power under a financial and a healthcare power of attorney to step in when the young person needs that help, right? We started talking about supported decision making, so the parent acting as that supporter. It's in the district, it's in the statute, so we're one of the few states that actually has it there. There's a supported decision-making agreement that shows that the parent is a supporter, that the person wants to help them so that the parent can get access to health records, to bank records, and assist their child or their young adult in making those decisions themselves. The powers of attorney are there as a more kind of legally robust thing, right? The statute also contains a provision, DC Official Code 21-2210, that lets family members step in and make medical decisions if their son or daughter were incapacitated at that point and they needed to make it. They can do it without a piece of paper, right? It's in the statute. It's there for them to use. So those are, when I was saying that there are other options for that 18-year-old, those might be a way. If the young person can understand that document, wants that help from their parent, certainly if the young person really could not understand that document, and the way, of course, we would get that is maybe getting a psychological assessment to check. A lot of the public school records that come from DCPS or their schools are really focused on educational supports, so it may not give you the sentence that you need. Obviously, in the district, we presume capacity to do a durable power of attorney, but if you are talking with your child and you know that they can't understand the document and they're really having trouble understanding what you're asking them, then maybe that isn't the option, and maybe guardianship ends up being the option. But I think what happens more often than not, when I ask the questions of our intake folks later, they're like, oh, the person is directing their services and their care, but the parents have this guardianship. And I was pleased this year, we actually had 2 get terminated for that reason. The parents came to understand that they did not need to be guardian in order to support their person, and we were able to go to court and convince the judge that a lesser restrictive alternative was a reason to terminate. I know in one of the sessions earlier, one of the judges said something about how you have to regain capacity to terminate a guardianship. I think he just forgot about this other part, but the fact that you can also lack capacity but be able to use a lesser restrictive alternative, and the court can agree to terminate a guardianship for that reason as well. Because families also eventually realize that the guardianships can be burdensome on them as well, right? You have to keep up with the reporting, and that's a big deal. And if you miss a couple of those, you can get removed and be replaced by folks on the panel, a stranger coming in making decisions, right? And that's not what you want. So a lot of times families go into it thinking this is the best way to protect my child, but they don't understand what that comes with in terms of baggage. So that's what I meant when I said it, if that helps at all. Did that answer the question okay?
Well, I think Ms. Patel and I just had a very successful story, and that, guardianship sometimes it's based on what the parent wants. And even me with my 18-year-old, I gotta let go sometimes. And a recent matter where the family say, oh, well, we didn't want her to have a baby, or we didn't want her to do this. And when you listen over and over, the subjects that I just want to live on my own and try this on my own. And at age 62, she finally got her independence because, we did what we needed to do to see what was in the best interest. It was, she had enough capacity to tell you exactly what she wanted to do. And so sometimes we think it's about protection, but it's really about fulfilling a need as a parent, and it's restriction. And so that's where we go, what least restrictive. And so.
Can I just add one sentence, which is I think all of this has to be paired with whatever the services are. Like it has to be a full, a wholehearted discussion of not just like the decision making, but also like what else is getting wrapped around this person when they turn 18. Because I think that influences so much of the other decisions that we're talking about.
I think we have one more question from Ms. Stevens.
I realize that it is 4:30, and Ms. Ivy Nixon is looking at me like it is 4:30. I can't believe you have a question. I thank you very much to the panelists. I really enjoyed this panel, and I'm just going to ask one of you to kind of briefly answer this question. You can decide. You can do rock, paper, scissors, and decide amongst yourselves who can do it. I think that in practice, we see that guardianship interventions are often filed, as you've been discussing, without a full understanding of what the statutes actually require, especially after people are appointed, and that the court itself takes on this agency role after people are appointed. And I find that especially family guardians don't understand that and are in some ways really taken aback by some of the things that, how we try to hold them accountable. How do you think that this part of the intervention process could be managed more effectively so that we can regularly discuss, except for every 3 years, what the least restrictive option is, and hopefully, in the end, create less work for the court for us to do? So, anyone who wants to answer that can go ahead. Thank you.
I can go. I'm sorry, I want to make sure I understand your question. So you're asking how the court can implement a process to explore less restrictive alternatives before. Is that what you're asking?
I'm asking how we can provide the accountability that we're supposed to provide, because once someone's appointed, it just turns into this agency function.
Right.
It's very hard to get them to the least restrictive at that point. What can we do in relation to those agency functions, the review of the guardianship reports, the having them come in for summary hearings, other than remove them and put someone in there who can get us there? I believe in a phased out guardianship. I don't think that, I don't want to get all in depth into what my philosophy is, but we have guardianships, they last for people's lifetime, right? And they have lawyers in there who are doing this when they really need case managers. So I believe in kind of a phased approach. I don't think a lawyer should be in there for 5, 10, 15 years. I think you need a really a caseworker in there to kind of get them to see what the okay, Miss Ivy Nix is looking at me. All right, so I'm just saying, how can we?
I think
how
you're
can we
answering
use the
your own
system-
question.
How can we use the system that we have, right? Because our accountability is only you didn't file this, you failed to file, you didn't whatever. How can we
I
use
see what you're saying.
the resources that we have, like the panels and the to get more Miss Cheryl right there into our fold to get those things done for them and to get them
I
out
think
of the system.
You were speaking to this a little bit earlier about what resources can we help the person, become connected to expand and strengthen their decision-making skills, even during the guardianship. And maybe that's a matter of, in a fantasy world, how the guardianship reports, they have to give an update on their medical status, their financial status, and maybe they also report on how we practice supported decision-making or how we worked on their independence in these areas. Maybe that's, one grand idea, perhaps.
Yeah, I mean, what you're describing reminds me of what is done in mental health community court and having, I hate to suggest more frequent hearings, but something just a little bit like a hands-on, sort of like putting in mental health community court, there's an ACT team, and the ACT team is involved in when the person goes to court, and the person has wraparound supports in the community, and they're getting checked on, and it strikes me that what you're envisioning perhaps is a system in probate court that is probably a little bit more elongated, but that allows for engagement from a whole team and is a more informal court system that is moving towards and checking, assessing how the person's doing in their support.
Yeah, they can also file motions before your guardianship review to terminate, especially if the guardians see capacity. Well, I'm gonna put a plug in. The court can hire me, and I can put together a highly effective team to go out and case manage. So, yeah.
I would say too, just to add the before the guardianship gets appointed part, right? I think there's been some discussion about questions that could be asked either in the petition or maybe during the filing process, or even if someone comes to the pro bono clinic for help or self-help center for help, just asking those questions of have you thought about these things? Do you know that this is the responsibility? But also I've seen occasionally the judges ask the family member, what do you think guardianship is? Not giving them the, do you know you have to do this and this and this, but saying, what do you think this responsibility is? And then letting them kind of say it and then explaining. Because, sometimes you get a family member who comes in and says, oh, well, that means they have to live with me and I have to get their housing and I have to pay for their housing myself. And we're like, nope, that's not a guardianship, right? That's family member. But just getting them to say what they think it is themselves and having the judges sort of ask that routinely might be a way as well for them to get it before it's a surprise. Because that is the thing I get really frustrated for families about. We see it so often that family guardianships end up within the first year or two where the family member ends up getting removed because they just didn't know how many things they had to file, even though it's said in the hearing, even though they get the booklet, even though GAP is there to answer questions. I don't know, does GAP still do their guardianship programs? Yes, so the orientation program, there's so many resources available, but it's just whether or not people have the ability to access them. If they're online, maybe people don't have the technology, all of that kind of thing.
But I think the workloads of the guardian has to be reduced because the system is overwhelmed. The resources are overwhelmed. The guardians, have a lot of caseloads. So I think on the front end, there has to be a practice put in place where we're really looking at those petitions and streamlining them and only putting forth those ones that are really meeting the criteria. So prevention is first. And then on the front end, we need to have a balanced caseload because you have to be able to really intimately get into the family and really understand what's going on to make the recommendation for termination or at least a restrict. It doesn't have to go from guardianship to termination. So.
I have my own answer, but I'll save that for you later, Ms. Stevens. Well, we thank you all. It's been wonderful.